Welcome. This is a meeting of the Family Law Subcommittee of the California Paraprofessional Program Working Group. Want to just check, well, maybe we can come back to public comment since Judge Wiss, you have a relatively short time. And you can see the two topics that we want to cover is just the review of the tasks. And I think that the lists got sent to the judges and to Mr. Khan in advance of the meeting, but I can bring that up. And so, but if you have some, Judge Wiss, you said you had some comments that you wanted to share with us, so maybe we can just start with that. But let me, oh, I should go ahead and take roll. Sorry about that. Bashan?
Here.
Hamilton?
Present.
McRae?
Here.
Olvera? I think she might be a little bit late. Sarouche?
Here.
And Judge Wiley?
Here.
Great, thank you. So before you have to leave and hopefully come back, Judge Wiss, did you want to just share your thoughts on this, on the topic of a conservatorship and guardianship for the paraprofessional program?
Thank you, and thanks for the opportunity to provide some comments. I'm a bit hampered because I don't know what the committee has been doing thus far and what you have considered. But my observations are that one, probate is significantly different and distinct from family and should not under any circumstances be subsumed under family law. Second, I have grave concerns about your list of tasks because there seems to be a misunderstanding and a misapprehension of these tasks. And as an example, number 12, petition for medical authorization. These are petitions presented by physicians when someone is in the hospital and has no relative to consent to treatment. It's not a petition by a lay person, and the petition requires a court to appoint an attorney of the subject of the petition. In addition, another example is number 13, resignation of conservator and resignation of guardian. A conservator and a guardian can't simply resign and leave the conservator ward without someone to act on their behalf. Another example is number 7, substituted judgment. This is a petition asking the court to create an estate plan for the conservatee. It's simply not something that can be filled out by a paraprofessional. So while I agree there are some tasks that are likely proper and would be helpful, and our court's access office often helps individuals with things such as limited conservatorships for developmentally disabled adults. This list of tasks is very concerning to me, and it seems to me there's insufficient background and input on this. So I think the only thing I could do today is to urge you not to simply adopt this list without some substantial input. So I know Judge Wiley asked me to join this meeting, and those are my preliminary comments. I mean, I don't know where you've been thus far on this, but I have a lot of concerns. There are many implications. Professional conservators cannot simply resign without having to report it to the professional board. I mean, there are so many particularities about this. I think it needs much greater depth of analysis before simply just sending off some list of this is what people can do. So I had another meeting at 12:15, and I'm hoping it's only going to last for half an hour, and I could join you again to hear your discussions because I realize I'm just kind of landing in the middle of your proceedings without background.
So Judge Wiss, I really appreciate your thoughts on this. And just to provide a little context, this list came from a letter that was sent as public comment from Beit Tzedek and Legal Services and the Public Law Center of Los Angeles, and I mean Public Counsel, I think, is who sent it. In any case, they had suggested that we consider each of these topics, and just what happened is when the working group, this subcommittee was looking at family law topics, they came up with a list of different tasks that are performed in family law cases. And then a decision was made with, there was discussion and decisions were made regarding whether those should be included or excluded from the paraprofessional program. So I think what we had in mind and what I was planning to do is put up this list and we would discuss each one, and the working group would discuss with the input from all of our guests, including you, whether those should be included or excluded. So there's not an assumption that these would all be included. The idea was that we would delve into each of these and see if they should be, discuss whether they should be included. And we were also hoping to get your input on whether there are any tasks that were not included in this list, because this subcommittee really doesn't have any expertise in this topic.
I mean, it's just very concerning to me because there are tasks, but the ones that are identified are not things that a paraprofessional can do. And I'm concerned that somebody's just given you a list to say, oh, this looks good, but there are grave implications here. And I think the list doesn't include items that ought to be on there and includes things that certainly should not be on there. And to just on this sort of the spur of the moment in an hour meeting, decide yay or nay causes me great concern. I don't think this list is complete or proper. And it includes many things that should not be on there and omits things that could be on there. So I would really urge you to create some sort of a other committee that is probate specific, that has a better understanding of these things.
And just to give more context, I think that the writers of the letter were urging us to include some experts, and I think they included the list not because they were trying to bring these items forward as well.
I think we lost you for a moment, so I'm not sure what the last part of your sentence was.
Oh, I was going to say that the writers of the letter had concerns as well. And that's the context.
They weren't recommending that these services be provided by paraprofessionals. They were saying this is why paraprofessionals shouldn't be providing at least these functions. So they were supportive of your position, Judge West.
That's correct.
And this is the only aspect of probate law that's being considered for the program now. We've already voted out that paraprofessionals will not provide services in the areas of wills and trusts.
Well, so this is the list that's not being included?
No, this is a list that was generated by a group of legal services organizations who, in general, I think it's fair to say, do not think that probate should be included at all. And in trying to clarify or emphasize how complex these matters are, they provided this list of functions or components of the probate practice, which I think they were concerned that the working group was not appreciating in its deliberations. So certainly it wasn't a recommendation that these be authorized paraprofessional tasks, nothing to that effect, really to make the point that probate is complex and the working group needed to spend more time exploring that. So I think it's exactly what you're suggesting and why we invited you all here today, and hope it is not something to be resolved in one conversation, but that's the intent, to now do the necessary deep dive to get the complete list of everything that's involved, and then begin to look at, are there things that would be appropriate for a paraprofessional to do?
Right. So, well, I'm glad to hear that. So I don't mean to bow out, but I'm going to, and I'll hopefully join back because I'd be so interested in what other folks have to say about this subject. So I apologize for leaving abruptly, but I hope to join you back and hear more of this discussion. Thank you.
Thank you.
I wonder if it's a good time to hear from our other guests now that we've heard from Judge Weiss, just to maybe Judge Amity. Hi, Judge Amity.
Sure. Hi, how are you? Nice to see you. Nice to see all of you. I share some of Judge Wiss's concerns. I think that there are maybe some very limited areas where some paraprofessionals could be of help, although I'm not sure that those are areas that could be carved out. So there are some notice and service issues that I think self-represented litigants struggle with and that they could use some help with. But I'm not so sure how you would carve only those pieces out because they're so integrated with the rest of the petitions. And I would agree that generally speaking, conservatorship and guardianship petitions have such important issues associated with them and do cross over so many areas. For example, general conservatorships, so not limited conservatorships. I think that those involve such important issues of capacity of the person that that somebody is seeking to conserve, that's an area where really you need more than just that. You need some, quite frankly, you need some legal advice or other professional advice. And I would be concerned that somebody that's not trained as a lawyer might not be able to give the full flavor of what that's about. I do think limited conservatorships are, on the one hand, do require some expertise, as was stated in the letter from the organizations that provided this list. On the other hand, there are some very strict procedural requirements that I think are difficult for people to meet, just because they are, as they should be, quite specific, but they are repetitive. And so I think there might be some small area where there's where some help could be provided. I'm not so sure that that help couldn't be provided, for example, by a self-help center. So I think that that's also an issue that was raised in the letter from the LA organizations. Guardianships, I think that they do cross over so much that that's an area of challenge. And there is so much with dependency and family court and parentage that I think that that's an area that would be hard for somebody to provide real assistance other than just here's the paperwork and how it can be filled out. But again, I think that's a function that could be met with a self-help center. So that's just sort of a very, very general overview of my feelings about it. Jonathan, who's our probate attorney, deals with more folks one-on-one. Right? What I see is when the paper's been filed and now I'm sorting out what the deficiencies are. But Jonathan's doing a lot more dealing with people directly. So I don't know if it makes sense to go to Jonathan at this point, if that's okay with you all.
Thank you for the invite, Judge and Fariba. I appreciate being able to participate. I'm the staff attorney for Santa Clara County, been on the job about a year, was doing general probate practice for about 9 years before then. I do meet with a lot of pro-pers seeking guardianships of the person usually. A lot of them have been to the self-help center that does an excellent job. Some of them try it on their own. It's very difficult. We have a number of local forms. I'm guesstimating maybe 16 total forms involved in getting a guardianship. So it is very paperwork heavy. I do think it would be helpful to have assistance of some kind. It seems like strictly the appointment of a guardian maybe lends itself to a paraprofessional. I also have concerns about more complicated issues of, if ICWA comes up with notice to a tribe, Native American tribe, other issues that can be involved in a guardianship. I think that's maybe where I have more concern, but just a straightforward, grandparents seeking guardianship, if it's uncontested especially, I think there could be a benefit there for sure. I just worry that where do you draw the line exactly of when it gets complicated? I don't know if I have an easy answer for that, but I do see some role there.
Can I just, I have a question actually also about whether or not we're only talking about guardianships and conservatorships of the person. That's the impression I had, that guardianships of the estate, conservatorships of the estate, those are not being considered. Is that accurate?
Yes.
Okay.
And I think also it was only limited conservatorships.
Okay.
I thought we included, we were talking also about general conservatorships too. At least considering, no?
I don't think we got so far as to exclude. Maybe the LPS has for sure been excluded.
Right.
Okay,
Sure.
okay, got it.
Yeah, and I did read that. I mean, LPS should be excluded for other reasons, which are usually that they're institutional players. So that's a whole different ballgame.
Can I make a,
Oops, sorry.
oh, go ahead.
And I was just wondering, since you do deal directly with the public, without naming names or any identifying information, just in general, what has been, what negative experience have you had with what we currently call legal document preparers, paralegals, and then positive experience, if you could share?
Yeah, I would say when they're positive, you may not even know that a document preparer has been involved. You know, you just get a package of clean paperwork. And so I may not always know, but when it's good, it's good. When it's bad, however, it's especially difficult for the court, because if an attorney, let's say, was representing a guardian or someone seeking a limited conservatorship, if there's procedural deficiencies, the attorney would be present in court. You could then explain what needs to be cleaned up, perhaps resolve it right then in court, or grant something subject to a declaration clarifying. So when there's no attorney, when it's a document preparer, they would not be present in court, either physically or on court call or Teams. And so you're left with a situation where you're trying to explain deficiencies to a pro per who doesn't understand what you're talking about and has sort of deferred to their document preparer for the work, which was improper. And it just feels like double work for the court. I know the probate examiners often express frustration that when it's done poorly, you sort of end up hand holding a document preparer and roughly doing the work for them. There's a perception that it's burdensome and frustrating when it's done improperly. So real mixed bag. I mean, I do think when it's done right, it's a service, but when it's done wrong, it's frustrating and extra effort for the court.
What I wanted to add, we just before this meeting had the first meeting of the pilot program, and I think the recommendation is there's going to be a pilot program. They're specifically discussing limiting in the first phase the subject matter areas. Family law was one of the ones that was clear, one of two areas that was identified. I do think that this issue regarding the conservators and guardianships, given the amount of concern that's been raised, really could be said, we're going to recommend they not be included in phase one of the pilot program. And then the issue of whether it should ever be included could be addressed as after phase one's completed. And the courts see, because the courts may see that it is helpful to have the paraprofessionals provided services. And one of the things, Jonathan, it's unresolved whether a paraprofessional is going to be allowed to sit at counsel table where they could not, whether they can speak with the judge or not, undecided, whether they get to sit there undecided, but in that normal role of where the counsel is being advised of the deficiencies in accounting where there's not tentative rulings, the fact that it's a paraprofessional versus a lawyer wouldn't make much of a difference because they could be there to listen.
Fariba, can I ask, because I think it would be fair to say you've been supportive of allowing paraprofessionals to have some role, especially in guardianships. Just in my own experience, having worked, started out my career at the Judicial Council, working in the dependency area, but seeing those dependency cases close out, and then often grandparents and other family members struggling to get the guardianships done or modify things later. I certainly feel like this is an area of need, but I'm wondering if you could speak to sort of your view on, because you've spoken kind of passionately about it, and I'm just think it would be helpful.
As I've said before, we at the Self-Help Center handle guardianships and conservatorships, both limited and general, in the sense that, well, for limited conservatorship, we have workshops for parents, and we help with the forms, but we don't go to court with them. And I think I'm hearing from Jonathan that our paperwork is, the paperwork that comes from people who've gotten assistance at our office seems to be pretty good. So
It's really good. Really good.
So,
Seriously.
and then same thing with conservatorships, but again, when it gets, we're not in court, and when it gets contested, we're not in court. So that's where the assistance is needed. And then same thing with just regular guardianships. I think that what I'm hearing, I was going to ask a follow-up question from Jonathan too, in that if these folks get training to make sure that their paperwork, they know how to fill out these paperwork, so you're not seeing these defects in them, would that help?
Yeah, absolutely. I really think it would. I know I've seen a few instances where it was a limited conservatorship and a paraprofessional helping out, and there was just an error with matching up the limitations listed in the court order with the petition. I mean, it's a relatively easy fix. If there was a little more training, I'm sure someone could figure it out. It's the same frustration I mentioned when you can't really explain it to the, they're not the attorney, so they're not in court to get the explanation. It can be frustrating, but with proper training, yeah, absolutely.
Yeah, which, kind of leads me to say that at the Self-Help Center, we have, I'm comfortable saying that we have very high quality control here. We have staff attorneys that work on these things, and they get training, and we, put initials on them. So we take responsibility for the paperwork, and our judges know, and Jonathan knows when it comes from our office, so they can send people back. So there's that level of accountability. So that's why in another meeting I'd mentioned that, if only licensed paraprofessionals can do this work, we just have to work on recognizing a threshold beyond which, and we've discussed this in other, like in just regular family law cases, is what is that threshold beyond which the case becomes too complicated for a paraprofessional to handle, no matter how much training they get. So when they have not reached that threshold, then with proper training and quality control, they should be able to handle it, just like Jonathan said, a regular grandparent or non-parent guardianship case. Okay. And I don't know as much about conservatorships as I do about guardianship. So Judge Emily and Jonathan, is there a way to is it even proper to say a non-complicated conservatorship case?
Well, so let me, I'm going to back up just for 1 minute if I could, because I just want to make sure that I say this out loud, because Judge Wiss addressed this question. I know it was in the letter as well from the agencies down south. I'm very confused by the fact that probate is somehow underneath family court in the way that things are structured. That's very confusing to me. Probate is not, for the most part, while they're a similar discipline, the law is completely different, and probate is significantly more procedurally driven than family court is. And there's a whole court structure that goes with probate that doesn't happen in family court, with probate examiners and probate attorneys. And so I'm very confused by that. Having said that, I do think guardianships belong with family court, quite frankly. And if I were queen of the world, the guardianship, the codes regarding guardianship would end up in the family code, but that's a whole different issue and a bigger issue somebody will deal with someday. Okay, having said all of that, I think if we're only talking about limited conservatorships, so if you all have already decided, or I would agree that a general conservatorship is not really well suited for paraprofessionals. I think that those issues, and the reality is, in a general conservatorship, you are limiting the constitutional rights of the person who's conserved. And it involves doctors and a number of other factors, and there are areas of abuse and concern. So I think general conservatorships that are not limited conservatorships should be left out. That's my feeling. Limited conservatorships, there's some percentage of those cases that are, I don't want to use, well, I'm reluctant to use the word rote, but on some level it's true, where there's no question that there's an adult now who has been disabled since before they were 18, and those facts are very clear. And what that case needs is the paperwork to be done properly so that the conservatorship can be granted. So I do think that there is a role, there are some cases where those are straightforward. And the vast majority of limited conservatorship cases, the parties are self-representing. So I don't know if there's a legal document preparer or some other paraprofessional in there somewhere. And a very small group of attorneys who specialize in that I do see in court sort of regularly, but there's a very small group of those folks. So I think that is an area that with the proper training might be suited to paraprofessional work. I also think that there might be some logic to having that be in phase 2 of whatever's happening with paraprofessionals to see how that works in family court and see if that could carry over. So those are my thoughts generally. I would say that I do see procedural defects in late conservatorship cases where there's no question that the conservatorship is appropriate. It's just a matter of getting the paperwork in order.
So if we were to say that the assistant, again, I have to think about the fact that we at the Self-Help Center do provide assistance with general guardianships. But as you know, our assistance stops at the time they leave our office, right? We don't represent them in court or anything like that. Could a well-trained paraprofessional provide assistance, because it is very form intensive at the start anyway, to be authorized to help with the forms, at least with the proper training? Or is that even too complicated?
I mean, from my perspective, I think there's some logic there. I'm very sensitive to the reality that Jonathan discussed, which is, and the same is true for lawyers and everybody else, that there are some paraprofessionals who are very good and who will have that training and it will be helpful. And then there are some where ultimately what happens is a probate examiner is fixing everything, down the road. Mm-hmm. So as long as the training was pretty clear, and as long as the limitation was very specific, I do think once a guardianship or conservatorship becomes contested, I don't know that that's all very fact driven. It's all very, whatever the issues are in the family. I don't know that there's any professional experience or help that can be, that really adds value at that point, because then it just becomes fact driven.
Right. That's definitely a threshold when it becomes contested, and we're kind of looking at that in various groups as well. That when some issue gets contested, then it per se becomes too complicated for a paraprofessional to assist. But as Leah mentioned, that my goal has been to try to provide as much assistance as possible before hitting that threshold. And what is that? And trying to determine that specifically in conservatorships and guardianships. And just to answer your question, why it's in family, Leah, if I remember correctly, it's based on that study, right? Or that survey, Access to Justice. Oh, Steve.
It's in family law because we determined that the non-guardianships or conservatorships actions were not going to be included within the scope of service for paraprofessionals when we made the decision on wills and trusts. But these were different issues that we thought may lend itself. And the most logical place to put it was with the family law group, as opposed to what we could have done and maybe should have done was creating a separate subcommittee on conservatorships and guardianships.
And you had your hand up. Your hand is up.
Yeah, it was up, but
Sharon
had her hand up first.
Okay, yeah, sorry, Sharon, I didn't see that.
Oh, yeah, no problem. I was just going to respond to Fariba and say that, your office is high quality, it's very well structured. It's attorneys. I'm sure if it's a new attorney and they don't know the answer, they come to you or they come to another supervisor. we have to keep in mind that a lot of these paraprofessionals are not going to be working with attorneys in their office. They may just be like a solo practitioner. And I don't know how that factors into the decision whether guardianships are appropriate for them, even with the right training.
Good point. I just want to say good point. I wasn't quick enough with my mute button.
This is Elizabeth Olvera. I know Steve Hamilton has his hand up, but I can wait to respond to Sharon after Stephen.
Go ahead, Elizabeth.
So first of all, I'm sorry for being a little bit late, dentist appointment. And so I'm here to respond to Sharon. A lot of the LDAs who are currently doing guardianships for self-represented individuals, doing the paperwork for them, they join organizations like CALDA, the California Association of Legal Document Assistants. And through there, they have access to questionnaires that were prepared and reviewed by attorneys. So essentially right now, what they're doing is they're asking the questions to the pro per and just filling out the questionnaire with them. Well, the customer fills out the questionnaire, and then the LDA prepares the forms, and then the LDA transfers those answers onto the forms themselves. So that's one way how these paraprofessionals these LDAs are helping now. Just a reminder, I am a legal document assistant. Do not do guardianships or limited conservatorship. So from that perspective, but it is something that the majority of LDAs are currently helping self-represented individuals with.
And just to like quickly respond to that, and I'm sure they do a great job, and I have no doubt that you do an outstanding job with everything that you do. I think that what we're talking about is a very different model. It's not a model where you're just filling out paperwork for a client, but like an attorney, you use some judgment and you read between the lines. And if, the client says, put 2 children, but I really have 3, or, you may question that. So it's very different when it's representation. And it sounds like this is it may be too complicated for a phase 1 pilot. That's my position as of this moment.
Okay, that's fair. I was just trying to emphasize how it wouldn't be a huge leap to educate people who are already doing the work. So that's all I was trying to highlight, that it's not like we're taking, Joe Blows off the street and putting them out to just, to give legal advice. There's a smaller gap, thank goodness.
Yeah, and that's a very valid point.
Okay, Stephen, I think you've been waiting very patiently.
Did you see my face grimacing? I have to step away after I make my comment. I'm going to step away. I'm going to have the audio on, but I need to step away from my desk. I would like to know from Judge Emity and from Jonathan, and to the extent Judge Wiley's had of experience in probate court dealing with guardianships or conservatorships, how big of a justice gap is there? So I would want to know, what is the percentage of petitioners that are appearing self-represented without counsel? And in some of those cases, they do have to provide financial information. Is it they choose to do that, but they have the resources to hire counsel, or is the situation they don't have the resources, which I think that's a significant segment based on the work Elizabeth already does and what she's related to us.
I could definitely speak to the guardianship piece because unlike I don't usually meet limited conservator petitioner before they come to court, but I typically do meet the guardians. I would say the vast majority are getting fee waivers and they're not represented by counsel. Most of them do come through the self-help center and they do an excellent job. But I mean, really, it's actually quite rare to see an attorney representing a proposed guardian of the person. Maybe I don't know as much about the conservatorships other than what I observe in court, but I would say it's, 20% have attorneys, if I'm guessing. Judge, do you want to help out there?
I would estimate, I think it's at least 80% of people in limited conservatorships are self-representing, and the number might be higher than that. Maybe it's 85. And, I was thinking through how many folks have their petition approved on the first time they come through. And I would say, and this is completely anecdotal, so Jonathan, maybe you can let me know what you think as well, but I would say maybe 60% of folks, the first time they come through, their petition is granted, paperwork's all in order, off they go. And the balance of the time, there are usually two problems. One is a service issue, and the other is, for some reason, the doctor hasn't prepared the capacity declaration quite correctly. So that's not really necessarily the fault of the person who filed, but they weren't able to communicate with the doctor for the doctor to do what they needed to do so I could go forward. So I would say that those are my two most common problems. And usually that just means people come back one more time and then we're done.
And even I have the few times that I've filed guardianships, I get the same notices too, because it is so specific and so form driven. I'll leave my thoughts before I take my quick break. My feeling is that we should reserve this for phase 2. It is an issue that if we try to subsume it within family law, I think it's getting short shrift. And I think that what we should do is just put that we're not ruling it out, but guardians conservatorships will be addressed after or during the phase 1 pilot program if it is voted on, and if not, it'll be considered at a later date. And that's not really a form of a motion yet, but that's what it'll be when I get back. I should be back within 5 minutes.
I guess I just wanted to clarify that phase 1 and whatever decisions are made regarding the pilot program, I think the working group is expected to generate recommendations regarding included practice areas and tasks for the overall program. And then separately, there's going to be recommendations about a piloted or limited rollout, which may involve a limited number of practice areas. But it's my view that we do need the working group to at least reach a decision separate and apart from whether or not this would be included in the pilot rollout. I see Dana and Elizabeth with their hands up. If you want to go, Dana.
So I think I've heard enough to conclude that general conservatorships are not appropriate, but I do think that uncontested limited conservatorships and guardianships, I would like to see continue to be included.
Okay. Elizabeth, were you gonna?
I just wanted to piggyback also on Dana and say the same thing. We've heard about this is the access to justice issue, delaying it by putting this in the proposed phase 2 that may or may not even come. It is a denial of access to justice, the very thing that we're trying to help people. So we identified that it is an issue. And so delaying it, we would like it to go forward. Yeah, just our thoughts.
Fariba?
So I also just want to repeat that it seems like barring contested cases, that guardianships, limited guardianships, regular guardianships can be included, and the threshold is if they get contested. I say that because I think the paperwork, first off, most of the cases we see, and I think I'm hearing the same thing from Jonathan and Judge Emily, I don't know if you agree, is that they are straightforward guardianships, they're not contested, most of the cases, anecdotal, I don't have stats right now in front of me. And that a threshold, a good threshold could be, if they did get contested, then paraprofessionals cannot have part of that, cannot appear in court and cannot be involved. And I don't know if it's appropriate to ask the group this question, Leah, so tell me if it's not. I just was wondering if people agree with that. I want to make sure Judge Amity and I hear comments from Judge Amity and Judge Khan. Would that be a good way to, kind of categorize the guardianship cases and make the threshold the contested when they get contested?
So first, I want to say that I appreciate the elevation that Judge Khan just received from Fariba. So,
oh, I'm sorry. Yeah,
pretty impressive.
My dad would be proud.
I think that the hard part is in limited conservatorships. I think that you could carve out contested or uncontested. The vast majority of those are uncontested, and the contest is not should there be a conservatorship. It's who should it be and or what should my visitation be, right?
Okay.
Guardianships, I think, are a little bit different. I think that more are contested than you think. A lot of parents show up at the first hearing. They've not filed any paperwork. There's some issue. And so I don't know how you would carve out an uncontested guardianship in the same kind of way. And I don't know how you tell a paraprofessional you can only do uncontested ones. So again, and my opinion about limiteds might be unpopular with other judges. I don't know, but I that is been I'm a little bit more on the fence about. Judge Khan, your thoughts?
I said Jonathan Khan.
I get a lot of letters, and they often say staff research attorney con or probate examiner con. So my job changes day by day. No, I would agree that it's just hard to know early on whether a matter is contested. I would say it's not unusual to hear that when I'm meeting with these guardians for the first time that they think mom's on board, but I don't know, she's erratic. That's a common scenario, and often there's a surprise where a parent does show up to contest. So just as a practical matter, it might be hard to spot that issue early enough. We often just don't know, in my experience.
No, what I was saying is when it gets contested, then the paraprofessional's role ends. And either the guardians can represent themselves or hire an attorney. But the paraprofessional cannot come to court and, continue to have a role in the case. I don't, you know what I mean? Yeah. So at the outset, every case could be uncontested or contested. Right. So even we prepare the paperwork and we don't help when there's a trial or anything like that. We get out or we refer people out. So that's what I meant. Definitely, we can separate limited conservatorships from, limited conservatorships and say, again, there is a huge need for assistance and paraprofessional assistance. There'll be a huge gap and access to justice. And I want to, kind of advocate for that to be included. And like Judge Amity, I'm hearing Judge Amity say that the mistakes that are made are really not because of the legal document preparers mistakes, but it's just that parents need to do something and it's late, right? Most of the time. Is that what I heard you say? The letter from the
I don't know, because I can't always tell if a legal document preparer or the self-help center has been involved. It's not always readily apparent to me. Mm-hmm. The service issues, if somebody has an LDA and the service issues are not handled properly, that can be a little bit frustrating. And let me just add one other thing. I think that we see that there are some cases with LDAs who've done an excellent job and the paperwork is very clean, or there is a delay, but it's not related to the preparation of the paperwork. I will say that there are, we do have the self-help center. I mean, again, limited conservatorships, it's all about the paperwork, and some of that help happens. And there are some, in guardianships in particular, there are some nonprofit organizations who do all of that initial paperwork sometimes, and who actually, they come to court, they don't come up to the table On rare occasions they do, but that's a strange exception. But most often they're sitting in the gallery, and so they hear the information. And so when we're talking about access to justice, and I agree that there are a lot of people who need more of the help that they get from an LDA, and that LDAs provide a lot of really important work. I also think that an exploration of nonprofits who do all of that is just as important. I mean, I think in terms of access to justice, a lot of those folks, the reason they don't have a lawyer or an LDA is they can't afford either one. So I think we have to recognize that there's also another piece that has to be addressed at some point.
And not all counties are the same. So not all self-help centers will help. And we have to also look at county by county resources available.
Right.
I think
Sharon, it looks like you've had your hand up for a while.
see that.
Yeah, I would just say that if we are like putting aside the issue of whether this is going to be part of a pilot and in what phase, I think that if we are going to be considering limited uncontested guardianships, we should at least dive into, the matters and the petitions as we did with family law. I don't feel comfortable just making a blanket recommendation of yes or no without doing that same level of work.
Elizabeth?
Thank you. So in the topic of contested versus non-contested, when a case becomes contested, we have attorneys we can refer the cases to. So we have great working relationships with different attorneys, and then we send the client to get that kind of legal advice for now. So that's one way. Yeah. That's all I wanted to say.
I'm wondering if this might be an appropriate time just to check in to see if there was any public comment, because we haven't actually done that yet. So, so let me just say that we have a couple of attendees. I want to just give you an opportunity, if you're interested in making public comment, to raise your hand using the Zoom function. And it looks like we do have one person, Helen Ballamy. We'll go ahead and give you 3 minutes to speak.
Thank you again for this opportunity. I've been away for a while, but it's good to hear that we're moving forward. I've said it too many times that I'm a legal document assistant as well as someone who assists the legal consumer. The legal consumer, when they come and do guardianships, is usually a grandparent. And all they're asking for is let's get this paperwork done, let's get it through the court system. Very rarely are they contested, and the contestant would be the parents. If they are contested, then I always refer them to an attorney. Being able to assist the legal consumer to get from point A to point B is very important. A limited conservatorship is actually most of the time for a person. It's not necessarily for the estate. Can you hear me? Am I muted or unmuted?
No, we can hear you. Go ahead.
Okay, I'm sorry. I got a pop up on my, I'm on my phone, unfortunately. I'm talking about legal conservatorship, limited conservatorships now, it's usually, again, a parent asking to continue to take care of their child. I have never come into where there's somebody, it has been contested. I would like to go to the next step with reference to general conservatorship. Again, you've got someone who's in need of assistance. We can actually say it's about affording an attorney or not, but that's not what the real issue is. It doesn't matter if somebody can afford an attorney. It's about whether or not they want to spend their dollars, because those dollars can be spent other places if there is a way in which to provide the same type of service, the same level of service. So I think that when we talk about whether or not people can afford with their dollars, that's the wrong focus. The legal consumer has a right to spend their dollars where they want to spend it. It should not be in one source. If you have a general conservatorship and you've got competent people who can provide that, why must they use those dollars for the benefit of another profession. That's not right. I provide services for general conservatorship. If they get contested, you need to go to the next step. But when it's very simple, you don't have to go to an attorney to get it done because it is paper intensive. It's all about getting the right boxes checked. It's all about getting the probate examiner to assist you. So again, I'm
You have
asking
30
with-
seconds left. Thank you.
I'm asking with a little passion that we keep the focus on the focus. It's about providing access, not maintaining the status quo. Thank you.
Thank you. Okay.
So we've got about a little over 30 minutes left. And it sounds like where we are is we want to continue the conversation about limited conservatorships and guardianships, both, but the caveat that we're talking about uncontested matters and needing to further understand. It sounds like in guardianships, it's not so clear cut as to whether or when something is going to become contested. And I think, Sharon, what you were speaking to is the need to do that full articulation of tasks, everything that's involved, the way that it's been done in family law. And I'm a little bit at a loss because the way we've done that in family law is really with Fariba and Stephen taking the lead, who have a very significant experience and are able to walk the group through that, and frankly did a lot of work outside of these meetings to make that happen. So it sounds like that's what we need to do as a next step. Is that what does the working group agree? And maybe we can talk about how we can get that done.
So I'll go first, I guess. So again, I want to clarify that we're talking about starting a case, and at the start of the case, we don't know if it's going to be contested or not. We don't know with the family law case if it's going to be contested or not. So it's just, so let's I wanted to clarify that. I don't want to volunteer Jonathan or Judge Khan, but, or I have two staff attorneys in my office that are we've met before. If you, Leah, are thinking we can follow the same path as Steve and I did with family law, we could certainly have that kind of conversation with experts like Jonathan or Joanna and Linda in my office, or if you guys can volunteer people or name people, and then go through the forms. If that's what, and the tasks, we divided them into issues and tasks and all that, and sort of try to make sense of it. Does that address your what you were saying, Leah?
It does.
And Jonathan's shaking his head. He's totally willing to do it.
Let's hear from the rest of the group.
Can I make just a very simple, maybe we should talk about them as pre-contested as opposed to uncontested, and that differentiates it a little bit.
Makes sense. Anybody else have thoughts or?
I think I have somebody I could volunteer from the county council's office here who's done this work for decades.
Do you know if your county council does limited conservatorships? Our county council stays out of them entirely.
I think that's true in Santa Cruz as well. But I think that she's had so many decades of experience that I think she could help us with the tasks.
I also know a number of people who do this work for nonprofits that do this day in and day out. And these are all low income clients, and we can bring them in as well to help us differentiate the tasks.
So maybe we need to convene a separate meeting with these subject matter experts. Maybe Sharon, if you identify one or two folks, in addition to Judge Jonathan, Fariba, maybe somebody else, and Dana, your volunteer, And maybe what we could do as staff is convene that group and sort of get that going separate and apart from this subcommittee. Does that make sense to folks? And then we have bring their work product back and then back to a subsequent meeting.
Leah,
That's yeah.
I had a question. Would it be appropriate I know Helen Bellamy has expressed interest, the person who just gave a public comment and who's an LDA and who's been doing this for many, many years, more than she'd like to admit, maybe. She says that all the time, so I feel comfortable sharing that. But would it be appropriate if she were part of it, because she's like on the ground floor, has her hands in it? If you're gonna do a separate group anyway, maybe her contributions could give you guys a different perspective from, you know, closest to the consumer needing the assistance. Just wanted to throw that out there.
Okay.
I think that makes sense. I'm not in charge. We don't have a chair of this subcommittee. So if anyone objects, let me know, but I think that would.
I think it would be a great idea to have that point of view. I really do. Just like I value your point of view, Elizabeth.
Thank you.
All right. So those of you that are slated to do so, please send Linda and I the names and we will follow up. Names and email addresses. And I think we have one more issue we want to cover before we close today. Is that right, Linda? Just the bifurcation of issues? Okay.
Yes. Do you want to explain that?
Yeah. So right now, this subcommittee is slated to bring forward its recommendations to the full working group at its February meeting. It's the only sort of practice area. When I say this, I'm talking about family, not the conservatorship and guardianship issue, but family law.
Leah, I just wanted to ask if Judge Amity, I know she has lots of.
Oh, yes, I'm so sorry. Judge Amity and Jonathan, thank you so much for your time. And you can stay to hear us talking about family law, but no need to. And we really appreciate you taking the time.
Thank you so much.
Yeah, and thanks for the opportunity to address the issues. Nice to see you all.
Thank you.
Thanks.
Good luck.
Thanks, Fariba. I blew right past that. So right now, the family law recommendations are slated to come to the full working group at its February meeting. However, also at the February meeting, we have scheduled a facilitated discussion on the topic of in-court representation generally, as applicable to any particular practice area, but really stepping back and talking about it from a policy perspective, really fleshing out the pros and cons. And Judge Rubin from our working group is going to facilitate that discussion along with me. So it seems a little odd for the family law recommendations to come forward, which presumably will address the question of in-court representation for the various aspects of family law proceedings that have been identified, to come forward at the same meeting where we're going to have our first full working group conversation about in-court representation. So I'm wondering what you all think about that. I talked a little bit with Justice Petru about some options for bifurcating the family law recommendations, that this subcommittee might bring forward all recommendations other than in-court representation in February, hold off on that piece until after this full working group discussion is conducted, or just postponing the submission of the family law recommendations. My only concern with that is we start to get very jammed up in subsequent meetings, because remember, we still have to come back to housing, general civil, employment, all of these other practice areas that have been on hold for a while. Or scheduling a separate meeting for family law, the family law recommendations perhaps to occur after that February working group meeting, but an additional meeting of the working group to take up family law. So, Freebie, I see your face, you look perplexed, but maybe it's something else. And I thought, am I being that confusing? So I don't know if anybody else has any thoughts on this. Hopefully I articulated the issues clearly.
Is there a downside to bifurcating?
Well, there's some, I think, who feel like and I wish Stephen was on, who have tied verbally the extent or the nature or the degree to which they will be comfortable with the paraprofessionals performing X, Y, or Z tasks to a limitation on the ability to represent folks in court. So I think that for those individuals, there would be a concern about bifurcating the issues. Anybody else?
Yeah, I think this really was Stephen that had voiced that, so it would be very helpful to have his participation in this discussion.
Do others have an objection to the idea of bifurcating or an objection to the idea of perhaps a separate meeting in March to take up family law, or moving it to April, just as I said, the April meeting? We begin to really compress our timeline.
Do we anticipate a lot of discussion?
On the in-court representation issue?
Correct.
Yes. I anticipate there'll be a lot of discussion. I think there are very strong opinions on both sides. I think you're going to hear a lot of public comment.
So then it would, I think, behoove us to perhaps to have a recommendation from our subcommittee before we hear the larger groups discussion, at least to get on the same page amongst ourselves with respect to what we believe the appropriate recommendation should be.
That's an interesting perspective.
Can I just jump, I've been silently lurking. I'm jumping in for a second to second Judge Wiley's thought on that.
Okay.
I think that would be helpful.
Okay, then I think it's a non-issue. All right. I think that's it for today. Is that right, Linda?
Yes.
Okay. So we gave you back 25 minutes.
Okay.
We will get working with the conservatorship guardianship strike team. Thank you all.
Thank you.
Bye-bye.
Bye.
Bye.
Everyone.